Welcome to a live episode of Surviving the Survivor. We bring you the best guests in all of true crime. Don't forget to subscribe and smash that like button. Here's your host, Emmy Award-winning broadcaster, Joel Waldman.
What's up, STS Nation, and welcome to another episode of Surviving the Survivor, the podcast that promises to bring you the very best guests in all of true crime. I knew I was missing something. It was the glasses, and another powerful show coming your way tonight. I'm going to introduce the guest. You definitely know one of them already, but for those who have been living under a bit of a rock here at STS, of course, it was, I hate this cliche, but it is appropriate here. It was a bombshell development last week at the trial of Donna Adelson. Of course, she is accused in the 2014 murder for hire killing of Dan Markel. Well, it went off the rails on the first day of jury selection after lead attorney Dan Rashbaum, right here in Miami, he withdrew over conflicts of interest, multiple conflicts. Of course, Dan Rashbaum had represented Charlie Adelson in his case. They lost that case. He was convicted. Donna Adelson tries to flee the country 1 week later. She's nabbed by the FBI. Now Dan is representing Donna. Dan had represented Charlie, and prior to representing Charlie, had represented Donna and Harvey. So it is an enmeshed family with an enmeshed attorney in that family. And after Dan Rashbaum basically withdrew himself before the judge could do it for him, Leon Circuit Judge Stephen Everett announced that the trial is going to be continued and that prospective jurors would be sent home. Of course, that's after me, Mo, and Steve Cohen and I made that 8-hour drive, which love being in Tallahassee. Don't love the drive so much, but had to throw that one in there. We're going to play some sound because, of course, Donna's co-counsel, Alex Morris, who's from Tallahassee, he implied in a little news gaggle right after the continuance that he's going to work on some plea negotiations. And then the SAO, the state attorney, Jack Campbell, implied the same thing. So what is going on behind the scenes? Who better to discuss this than, of course, Tim Jansen, famed Tallahassee defense attorney, R. Timothy Jansen, the letter R, the O-U-R as well. He's a partner in the firm Jansen and Davis. He's handled all kinds of complex civil, administrative, and criminal litigation, and he spent 5 years as a federal prosecutor prior to that. We've got Judge Jay Blitzman, who teaches at a little school called Harvard Law, who's scheduled to be on here as well. And he, I think, is just running late because I've been in touch with him. I think he knows it's happening. I've got Steve Cohen on it right now. And certainly last but not least, and this is a special best guest, and I'll tell you why in a second, this is the Honorable Eugene Michael Hyman. He's an American retired judge, a lawyer, and a former police officer, and he hails from the great state of New Jersey, Perth Amboy, New Jersey, to be precise, but he was a Superior Court judge in Santa Clara County for almost 20 years, and he also served as a legal analyst. Little known fact, my father, may he rest in peace, he was a psychiatrist. He had a private practice, but he liked to make a little extra coin on the side, so he would go to Perth Amboy General Hospital to sign paperwork for inmates a lot of the times. It was interesting. It's always a scary place. And then I find out that Judge Hyman was born in that hospital, and then Judge Hyman tells me Bon Jovi was born in that hospital. Are you still proud to be from New Jersey, Judge?
I'm proud of Bon Jovi and the boss.
The Boss. There we go. Two great people. And you never lost your roots despite being in California for a couple of minutes now.
Well, I moved here in 1970.
That's a little while ago. There you go. I was born in 1969. So there you go. There's a little frame of reference. So let me get kind of right into this with a piece of sound, as they say in the news business. This is, by the way, the second show of the day for both Tim Jansen and myself. Tim weighed in on Diddy. That's a whole other ball of wax, and we're going to be following that. I think we're going to have a panel of all former inmates Thursday afternoon to discuss that at 12:30 to get you a real feel of what's happening inside of MDC where Diddy is being held. But so here is Alex Morris. This is after the trial, for all intents and purposes, just imploded. It blew up. And here is Donna's attorney. For how long? We don't know. We're going to ask Tim about that. But let's listen to Alex Morris.
I think that it's going to open up opportunities as it relates to negotiations. I think that it opens up pathways to exploring different defenses that may not have been previously available. I think that it makes the situation potentially easier and in the best interest of both Mr. Adelson and Mrs. Adelson in terms of having lawyers advocate for them.
Tim Jansen, and listening to that just now for the 900th time, he's a little, when I'm listening to it now, he's a little more ambivalent in his answer, I think. He doesn't sound quite as confident as maybe I thought the first time. By the way, we had engineering in here in global headquarters. The COE was here. By the way, Judge, that is the wife, the chief of everything, the COE. And despite her best efforts, she told me the camera was up and running. It is not up and running. So engineering will have to be back in the house tomorrow. Shout out to TYO Toys in the house, who made me a little personalized, tiny little Ferrari that I absolutely love. But Tim, what's your best guess right now? We're now, basically a week removed from this. Alex Morris, who you know very well, has had time to digest this. Is he going to stay on? Can he stay on?
Well, I don't think the state's going to agree. And there is no plea deal in the works, per my sources today.
Listen to that. Per his sources today. Judge Hyman, if you can, and the judge is out in California, he knows the case to an extent. He doesn't know like the insiders, but what he does know is how to judge, and he knows the world of law better than most. So, I mean, Judge, just from a macro perspective, you've got this first suspect who's convicted, Charlie Adelson, who they say helped orchestrate it along with his mother. He's convicted. A week later, the mother tries to take off to Vietnam. She's captured. She was supposed to stand trial. What sort of plea deal do you think could potentially be offered? That's the focus of tonight's show. Trying to broker a deal. So what kind of deal could be brokered here, do you think?
I'd like to back up a second, because in order to broker a deal, you need to have the attorney substitution has to take place. And this is a nightmare for a judge, because you have a lawyer who's currently representing the party, and the lawyer says, I have a conflict. Now, judges hate this situation because the judge is not allowed to specifically ask what the conflict is. Because if the judge were allowed to do that, and if the lawyer answered it, the lawyer might be giving information that somehow might violate the attorney-client privilege. So that's problem number one. Problem number two is that under the law of any state, under the law of federal considerations, is that a judge does not have to accept a resolution between criminal parties, i.e. the prosecutor and the defense attorney. Just because they've come to an agreement doesn't mean the judge is required to sign off on it. Judges are supposed to do things in the interest of justice. So if the judge is of the opinion that the attorneys have come to a resolution, but this resolution is not in the interest of justice, in the interest of the public, then the judge can reject the resolution, and the parties either work out a new resolution, which the judge can accept, or the case continues. Now, the reality is, statistically, Most resolutions where the prosecutor and the defense attorney come to an agreement, the judge usually signs off on. Now, whether that's done because the judge honestly believes that that's in the best interest of justice, or whether the judge signs off on it because the judge wants to end and get rid of the case, that depends upon the individual case, depends upon the individual parties, and depends upon the individual judge. I mean, there were situations where I had a DA and a defense attorney present to me a resolution, and I had some concerns about it, whether it truly was in the interest of justice. But because I had such great respect for the prosecutor and the defense attorney, that helped me resolve it in favor of accepting the resolution. On the other hand, on a couple of occasions, I didn't have that confidence. I didn't feel comfortable with it, and I rejected it. Now, the other concern, and I hate to be taking up so much of your time, but
That's a podcast. This is good.
That's what judges do, right?
Take up time. That's not nice, and you're lucky you're not in front of me, or I consider contempt. At any event,
won't be the first time, Jeff.
I'm sure you have a bail bondsman on speed dial. I know. So I'm sure you do. So I have every confidence that you do. So another concern is that when a case is sent to a judge for trial or for a hearing, in other words, the case is not sent to the judge for purposes of a settlement conference. The case is sent to a judge for purpose of doing something, whether it be a motion or whether it be a trial, whether it be a jury trial, whether it be a court trial, also known as a bench trial. A judge has to be very, very careful about being involved in trying to resolve the case. A smart judge is going to say to the prosecutor and the defense attorney, do you waive the potential problem of me acting as a settlement judge? Because what a sneaky lawyer will do is that if things aren't going that particular lawyer's way, and the judge is tipping his hand in terms of what the judge might do with respect to an evidentiary ruling, the defense attorney will say, nah, you're gone because you're acting as a settlement judge. We were sent here for you to be a trial judge, and you've crossed the line and you can't go back. And when you look up the cases in the code sections, absent a stipulation, the judges cross the line and the defense attorney gets a shot at a new judge. So this is fascinating for all those reasons. A judge has to be extremely careful. And then, assuming that you accept that the defense attorney has a conflict without knowing totally what that conflict is, then you say to the defendant, you've got an important decision to make here. It's called voir dire. You ask questions of the defendant to make sure that the defendant is knowingly and intelligently making a decision, an important decision regarding changing counsel. Because you say to the defendant, this case has already begun. I, the judge, have to be very careful in terms of how I handle things. If you don't want this lawyer to be your judge, then I'm put in the awkward situation of either denying the conflict, denying the lawyer the opportunity to leave, or you, the defendant, have to waive double jeopardy and consent to a mistrial. So what we are talking about here in a matter of a few minutes in real life is going to take hours to unpack. I mean, this is a great law school final exam question. I mean, this is just packed with intrigue and problems.
Yeah, and we have from Jersey as well, University of Nebraska law professor Jo Patuto, who's on the show. She is the actual law professor, and maybe we'll team her up with your honor for a future show. Tim Jansen, I assume since you are one of the better-known criminal defense attorneys, that you did well in law school. Did you follow everything the judge just said? I did not know that the judge needs to essentially sign off I guess it makes sense, needs to sign off on any potential deal. Your sources in Tallahassee telling you there is no, plea going on right now. Do we know if there is a negotiating starting point? Is it something? Is Alex yet to start negotiating, or has it been shut down, or you're not exactly sure?
The judge is absolutely correct. The judge makes the final decision whether to accept the plea, right? He has to accept the plea that the defendant is knowingly waiving his right to a trial and accepting the terms of the plea. So got to make sure he's not under any threats, that he's not promised anything outside that plea negotiation, that he's not under alcohol or drugs, doesn't know where he is. But he's right. If it's such a one-sided deal, the judge can pull you to the sidebar and say, why is this happening? Now, Judge, in Florida, we have a thing where the victims have victims' rights. They have a right to be told of the plea, and they have the right to give a victim statement. And I've had a murder one case recently where the victim's family objected to the plea offer, and the court accepted it, understanding both parties met with the judge and explained to the judge what was happening. And it was a 6-year-old murder trial. And so you're right. My information is there's no negotiation. Nothing's been done, and nothing's probably going to be done. Alex is not totally going to be the lawyer. It's not determined yet. The state believes he has a conflict. Judge, the conflict in this case was he represented Charlie and had attorney-client privilege. The state was going to possibly call him as a witness in case in chief or in rebuttal. He would not waive the conflict, so that lawyer couldn't cross-examine him. He had co-counsel who said they put the Chinese wall up, ethical wall. We don't call it Chinese wall anymore. But and then they inferred to the judge that they had a third-party lawyer who was retained and is ready to do cross-examination if the wall's not complete. And then when the judge asked a couple questions, well, when did you retain this other lawyer? They hadn't retained the other lawyer. And they just talked to him. And then they asked the defendant, are you aware of what's going on? And she had to look like, no, I don't know who I am or where I am. So the judge, of course, after break for a couple hours, probably did some research, talked to another judge. He was shocked that this came up. There was no written waiver. It was an oral waiver. And that's not much of a waiver. And this kind of waiver can change his mind anytime. It's the defendant's right, not the lawyer.
Yeah. So let me try to break this up a little bit. By the way, COE, if you can, the judge has not seen my interview with Dan Rashbaum, the defense attorney who stepped down. But I interviewed him back in January, and he made it abundantly clear that he had signed waivers from Donna, Harvey, and Charlie, which seemed to not be the case. And I'd like you to take a look at that if the COE can get that up there. But there's so many questions to be asked here, Judge. The first one from me to you is, did the judge screw up here? Collectively, everyone thinks he's an excellent judge, Judge Stephen Everett, circuit court judge. Did he screw up by not anticipating this implosion earlier on?
I don't think so. Trials are,
fluid.
Fluid's that's an excellent word. Thank you, counsel. We tell, jurors, I probably did 150 jury trials in 20 years, and I wasn't in the criminal division for all 20 years. But, jurors are always amazed. I give jurors the opportunity to talk at the end of the case. They ask questions, assuming I can ethically answer the question. One of the questions that they always have is, how come so many times we need to take breaks for me to meet with the lawyers or to do something else? It's like, how can we be, quote, so unprepared, quote? And what I try to explain to jurors, because I think it's very important that I give jurors confidence in the system. I mean, after all, the odds are pretty good they're going to be subpoenaed for subsequent juries before the end of their life. And I want them to think that this is, not the three Keystone cops going around here that, just because you have a police report, just because you have a preliminary hearing, just because you've had, statements in other situations, doesn't mean that things don't all of a sudden become strange. I mean, you can't totally predict how stuff is going to happen. Based upon what I know, what little I know, because the two of you certainly know far more than I do. I really don't think, and I'm not just trying to stick up for this judge because he's a judge. I don't know him. I'm trying to place myself in his shoes. I really don't think he could have anticipated all of these difficulties. I really think. I mean, I've been in a situation like this, nothing quite this complex. I mean, this is like I said, this is a law school final. I've never had one of these, but I certainly have had lawyers declaring conflicts. I never had a situation where someone else was ready to jump in during a proceeding. If they declared a conflict during a trial, and if I granted it, it meant an automatic mistrial, and double jeopardy didn't apply. And so the trial got to start anew. But, look, this is the last thing a judge wants. It's the last thing the prosecutor wants. It's something a defense attorney wants, to start over again, because you already know a lot of information, new information that you didn't know before as a result of putting on the case to the point where it ended. But judges don't want to start over again. It's a huge imposition. It's a huge investment in time. And that's why you try to prevent it by asking a lot of questions. But having said that, it is critical. And I agree with counsel. I forgot to mention this. Thank you. The victim's family, the victim and or their family, have the right for input. It isn't just the judge that has to decide this is in the interest of justice. One of the factors that the judge considers is victim input, assuming that the victim wants to have input. Now, sometimes a victim or their family shows up for input. Sometimes they gave input to the DA and they asked the DA to read it. Sometimes they give it to a victim witness person who reads it. But the end result is they are entitled to give input to the judge. And what is sometimes extremely difficult is you have a victim or their family, in the case of a homicide, they feel very, very strongly that this settlement is wrong, and they want the case to go on because they want this guy convicted of first degree with special circumstances and everything else. And they feel that the defendant is getting too good a deal. So the judge is placed in the awkward situation of trying to explain to the family why the judge believes it's in the interest of justice to accept the plea over their very strong objection.
So,
By
Judge,
the way,
I'll give you an example, Judge, of what happened in a case. It was a truck driver that hit somebody on 75 and she was killed. And the trucker left and went, and they eventually arrested him for DUI, manslaughter, negligent homicide. And so the person that went to where the truck was being repaired, right? He talks to the guy. He admits he's the driver. Now this highway patrolman is an air marshal. So he's flying all over the country, and a judge wants to try this case. So we perpetuate the testimony of the air marshal, and he puts him under oath and everything, and we're getting ready for trial. Only one thing, it didn't get recorded. So the testimony wasn't perpetuated, and we're set for trial. And the prosecutor goes to the judge and goes, "Judge, we got this plea offer of probation." And he goes, "But the family's objecting." And we go to sidebar and we tell him what happened. And he goes, "I'll handle this." And so, of course, he accepted the plea. And he only told the family that sometimes evidence comes in or doesn't come in, and you might not get anything, but at least we'll have jurisdiction on this person. And he got probation, all because that recording button didn't work. And it was set for trial. And the family was upset. And it really put the judge in a bad spot.
Yeah.
And the judge is going to be the one who's going to be viewed as the problem in this case. And the judge is going to have to maybe face an election, and this might be used against them at the time of the election.
But the best part was the prosecutor during the case says, "You have no defense. You have no defense. You should plead him." So after we left the sidebar, I said, "Well, I had a defense."
By the way, this is fascinating to get the judge's perspective, which we often do not get. Who needs Jay Blitzman when you got Eugene Hyman? But I'm hoping
Judge,
Jay does show.
I'm sorry, Joel, but to make this a little more complicated, okay? So the judge is finding out about this conflict, and then they say, we've got a third-party lawyer, and he says, Ms. Adelson, have you spoken to an independent lawyer about this? They took a break, and this lawyer walks in and talks to her for 30 minutes during lunch, comes back and says, yes, she's willing to go forward without her main lawyer. And I've explained to her that I haven't had any time to prepare, but I'm going to do the cross-examination of Charlie, right? So this lawyer, it hasn't been on the case, hasn't read anything, but she's willing to now waive, and he's going to be prepared for a murder trial, first degree. And the judge just says, hold on, this is not working. This is not happening. And of course, he did the in-camera for Alex, the second lawyer, and he brought the original lawyer in. But the question is, why would they move forward with the second lawyer, which the ethics the ethical wall may not have been enough, and you're bringing that issue again in another year? Why would you do that? Why wouldn't the judge say, listen, you're out. Your Sixth Amendment's not absolute. We're going to start from scratch with all new lawyers.
What about that, Judge?
Well, again, I'm not speaking for this judge. I don't know this judge. And
he's a great judge. He's a great judge, by the way.
Well, I don't know all of the facts. What I can say in general, very general terms, the following. One, judges are very reticent to grant mistrials and to start all over again because you've got so much invested time-wise.
Well, Judge, look, this is just the trial had not started.
Oh, it hadn't.
They did not pick a jury. They didn't do anything yet. No double jeopardy attached to jury. Not one juror was even called up to the courtroom.
Yeah.
Well,
yeah, go ahead.
I don't know. I mean, if it were my situation, given what you just told me, I would not have been as reluctant to grant a mistrial.
Yeah. Oh,
me personally.
Oh, yeah.
But I don't know all the facts. Yeah. But me personally, if there's no danger of double jeopardy, then the investment time-wise isn't as great, and I'd be more inclined to start all over again.
Right.
By the way, Judge, do you get good?
Go ahead.
Do you get good parking spots when you're a retired judge? Can you park wherever you want?
You don't get any parking spots. You have to go through the metal detector when you're a retired judge.
Oh,
what are you talking about? You're treated like lawyers.
You're treated like lawyers. From Boston Sarah to Tim Jansen, and we'll start to deconstruct this. If Donna were able to take a plea, Tim, what would that look like? This has come up before, and it's an interesting question. And keep in mind, we're talking about a possible plea in today's show. What would it look like, being that Charlie maintains innocence, and would a plea deal guarantee Wendy's arrest and prosecution? How does that work if Charlie says I'm innocent and Donna says I did it, but the defense is tied into Charlie being guilty? How can that happen?
So, Judge, the defendant on trial now is 74 years of age. The state believes she was the impetus for the whole thing, that she was the one that pushed it.
Right.
And her loving son was the one, the doting son was the one put the team together. Right. He went to trial with a cockamamie double extortion theory that the jury bought, 3-hour guilty verdict on everything. And they're not going to give Donna a deal. There's no deal to be made for a 74-year-old woman to think that organized a hit on a professor, a young professor with 2 kids. There's no deal. I'd be crazy, but no deal. What are you going to give her? 25 years instead of life?
It's a life sentence at that age. Whatever it is, it's a life sentence. They're going to die there.
Years is life, right?
They're going to die there.
Right. Thank you to this gathered nest for this little super sticker here. We do have the best guests in true crime. Steve Cohen, booking people like Your Honor, who is here, and obviously Tim Jansen, who's been with us for a long time. Someone said it is a smart show. I'd say this is probably one of the smartest shows on TV because we got the best guests. I sit here and I learn every single night. We're going to get to some other questions. I want to play. So, Judge, I interviewed Dan Rashbaum. This was Charlie's attorney, Donna's attorney, who just withdrew from the case. This interview is from this past January. after Charlie Adelson's conviction and while Donna Adelson was sitting in jail?
You asked whether there's a conflict now, and the answer is yes. There is a conflict. It is a waivable conflict. So with ethics, lawyers, and waivers by all the relevant parties, that conflict has been waived. And as a result, I now no longer represent Charlie Adelson or Harvey Adelson, but only represent Donna Adelson. So just to be clear, when you say, were you fearful that there was a conflict? There is a conflict. It just happens to be a waivable conflict that has been waived by everyone.
So Harvey, Donna, Charlie all had to sign something agreeing to allow you to be Donna's attorney solely.
Correct. And they had to do so. The most prudent way to do it is with an independent counsel advising them so that I'm not part of that decision-making.
So, Judge, you saw I got the Jersey follow-up in there asking him, did he get the signed waiver? And he said, yeah, but there was no signed waiver. So, I mean, but from what I understand, it could be rescinded at any time anyway.
Well, I would not just accept a signed waiver. I'm going to voir dire or ask questions of all the parties. I'm not just going to accept a waiver and say, hey, that's good. You're going to voir dire everyone.
Judge, sorry to interrupt you. Just going to introduce the other judge. Judge Jay Blitzman teaches at a little school, as I said, called Harvard Law. Judge Jay Blitzman, meet Judge Hyman, Eugene Hyman, from Jersey. Judge Blitzman is from Queens. All the great, they say, Run DMC, I told you, from Queens come kings. Then you've got Jersey and Tim Jansen in Tallahassee. So we've got both judges here, and we're talking about possible plea deals. Go right ahead, Your Honor, Judge Hyman. I did not mean to interrupt.
Oh, no.
Let me say quickly, mea culpa, or as we say in Queens, my bad for being late to the party.
No worries. No worries.
No worries, Your Honor.
Yeah. Tim's loving it. Go ahead, Judge Hyman.
Well, again, a lot of things that we're talking about, you've got the law and you also have legal culture. And, the public doesn't really understand the cultural aspects of it. If you commit a fish and game license violation in San Jose, you're going to get one consequence. If you do it in Northern California, where fish and game is a big tourist attraction, and you're violating, you're spotlighting deer and shooting them when they're in the spotlight, you're going away for a long, long time. If you do it in San Jose, there's going to be consequences, but nothing like if you do it in Northern California. That's an example of legal culture. So legal culture might be when you have written waivers, you look at the waiver in terms of how it's phrased. You maybe talk a little bit to the lawyer who you have to be careful again because of attorney-client privilege. The lawyer who advised the party about the potential waivable conflict. And then you're going to need to make findings that you find that the defendant was aware of the potential conflicts, was adequately advised about the potential conflicts, and knowingly and intelligently waived the potential conflicts, and that you, the judge of the case, are satisfied that there's a total understanding of what's going on here, and you're satisfied that he understands the potential problems as a result of the waivable conflicts that existed, and you accept it or you don't accept it. It's that basic.
Judge Jay Blitzman, we haven't had you on since this trial implosion, essentially, in a nutshell, and Tim and others can explain it much better than I. They got notice, Charlie's appellate attorney, I think on 9/11 of all days, that Charlie was going to be called as a witness. That's when he said that, he was not going to waive his rights, and then got involved and ultimately says he did not want Dan Rashbaum representing Donna Adelson either. So it's just this enmeshed, crazy set of circumstances where Dan then withdrew himself. The lead attorney and the co-counsel, at least for now, is leading the way with Donna. We don't know for how long. We'll get your reaction to that. But then this question for you too, Judge Jay. The argument on behalf of Rashbaum is Donna's Sixth Amendment right. Is there any case law, talking about putting someone on the spot, or standard when weighing the attorney's professional responsibilities / conflicts versus the client's Sixth Amendment rights? Do you have an answer for this one?
Well, first of all, as regards the withdrawal, better late than never. So joining this conversation midstream, yes, I concur with his honor that a rigorous colloquy, call it a voir dire, or as they say in Alabama, a voir dire, will be necessary to ensure that the waiver of what clearly is an appearance of conflict in representing co-defendants, essentially, has been made knowingly and voluntarily. It's always easy to be a Monday quarterback and to opine after the fact, but I'm from the point of equity, due process, and fairness. This attorney did the right thing. Maybe it could have been done earlier in the process, but certainly when his former client is now called as a witness, how can you ethically represent another client when you have a former client who might be called as a witness in the case? So that type of conflict, the appearance of a conflict, it seems to be insuperable. As regards the fundamental question, an attorney's obligation is to be the champion for his or her client. The right of an accused who is presumed to be innocent until and unless proven guilty beyond a reasonable doubt is paramount. The ABA and every state's ethical standards, every state's professional standards elevate and prioritize the right of the client to be heard. This is not a question about the attorney's rights. The client's rights to be presumed to be innocent and to have a fair trial before an impartial fact finder is paramount. So the client's rights prevail. And one of the questions I would have, and I would love to hear from my colleagues, is that I would hope and assume that there's a sufficient firewall between the attorneys in this case, because this is not as if we have an attorney coming in from another office or another appointed attorney.
So,
the attorney
I don't mean
had some connection or association with this case.
Yeah, so Judge Jay, Tim can fill you in on that. Tim, you want to explain where we're at with the firewall here? And then I've got some follow-up questions for Tim.
So the firewall was the second co-counsel. And apparently they divvied up things, and he was going to do the cross-examination. And they filed a motion with the court. They responded to the appellate lawyer saying, our client's not waiving his privilege. You can't cross-examine him. And in fact, we think co-counsel is tainted also, that he cannot do the cross-examination. So Donna's lawyers said, well, we have a third-party lawyer if the ethical wall is not sufficient to the court that has been retained to do the cross-examination. So, of course, Judge Everett said immediately, okay, who was this counsel? When was he retained? Okay. Donna, were you aware of this? Did you sign off on this? And all the questions were no. And the defendant looked like she didn't had this the first time she ever heard these questions. And it gets worse, Judge. They brought in this so-called third-party lawyer who spent 30 minutes with her, and then he counseled her that she would waive the continuance, go forward with this new lawyer to do the cross, and he hadn't seen the case yet, and he was the same one that was going to be hired to do the cross. So he wasn't independent. He had a little bias, right? Because he was going to get hired to do the cross. And the judge, of course, did it in camera. And luckily, 2 hours later, Rashbaum told the judge, I'm going to withdraw, because he has to. He can't. It's not really a way. It's a waivable conflict, but he has a right to withdraw the waiver, and that attorney-client privilege is sacrament, right?
It's sacrosanct. It's sacrosanct.
And so now the judge, okay, asked the second counsel, "Are you ready to proceed?" And of course, they divvied up the work, so he wasn't ready to proceed. He did one part, and so now they have, and he wants to stay on. But the question is, why would you have him stay on? Why wouldn't, as a judge, now you've been burned by this thing, require all fresh new lawyers so there's not going to be this issue in the future, right?
I guess back to Judge Blitzman, to me, this question keeps coming up. So Dan Rashbaum said to me in an interview that he had these waivers that they were signed. And he said there was a conflict. So I guess someone pointed out he's not necessarily lying. He's telling you the truth. But my question to you, just very quickly, is why have these waivers if they can be rescinded at any time? How do you enforce
there's a waiver. There's a waiver, but there's a conflict, and the client, the waiver manifests the willingness of the client to proceed in spite of that, to waive the conflict. I think the dynamic here, which has shifted from my understanding of the case, is now that there's an appellate counsel involved looking at the appellate record and preserving issues for appeal. One of the issues which is inevitably going to be raised is going to be the effective assistance of counsel. And I don't know Attorney Rashbaum, and as I said at the beginning, better late than never. He's in a difficult position. Again, you all have been following this case probably much more attentively than I have up in Massachusetts, but he did the right thing, albeit belatedly, perhaps. Whether or not there should be an attorney from who does not have any connection to the case, has not been retained or involved in the preparation of this case. I think that's an issue that should really be thought long and hard about by, quite candidly, the client.
Judge Hyman, question to you. Here's one right here. Southern Mom. What are some conflicts that are not waivable? Can you give us a few examples of something that is not waivable? And then I had a follow-up question, which I'm going to try to remember what it was while you answer the first one.
I'm having trouble thinking of off the top of my head of conflicts that can't be waived because.
Well, Judge, I can give you one because I do it all the time. You got a husband and wife that get arrested in a car, right?
Right.
And there's a bunch of drugs in the car.
Right.
And the one lawyer wants to represent both the husband and the wife. And the DA wants to give the wife a deal, right?
Yeah.
So you got divided interest, divided loyalty. You can't do that because what's good for one is not good for the other.
No, in that situation, you can't waive the conflict.
Right.
This happens all the time.
Let me say this. I was a public defender for 20 years before I became a judge. And there's some things that are axiomatic. You can't represent co-defendants. Essentially, these are co-defendants, not contemporaneously, but sort of on the installment plan. You know, her son is tried first, and now she's being tried. But they're all part of this overarching allegation involving a conspiracy. So it's like if you're representing this client in this circumstance, it's sort of like walking through a minefield in combat boots.
It's not worth it. Yeah.
Yeah.
I had a case, Judge, where I was representing a client for first-degree murder, representing him, attempted first-degree murder. And then I get a call. Someone called me wanting to talk to me about another case, right? They're telling me on the phone what their case is. And lo and behold, I find out 15 minutes, it was the victim in the attempted murder case. So now I have to withdraw from both cases.
Both, exactly. Because once and that's attorney-client privilege, you cannot share privileged information with client one with client two. And that's part of the reason why this situation is so problematic. That violates attorney-client privilege. And as soon as Charlie, through appellate counsel, raises this as an issue, it's, danger, Will Robinson. Attorney Rashbaum did the right thing. Again, we could talk about whether it was late in the process. I'm glad he did the right thing. It's easy to sit and judge, but this is as they would say, a sticky wicket.
Well,
Yeah, by the way, tomorrow
Dan didn't bring it up. It was the appellate counsel who filed a motion to remove Dan. It wasn't like Dan came in and said, "Judge, I've got a conflict now." He didn't do that.
Tomorrow we're going to discuss.
Then he did the right thing.
Of course.
And tomorrow we're going to discuss exactly what Judge Jay was just talking about, which is what happens to all the attorney-client privilege, back and forth. Alex Morris, Dan Rashbaum, the appellate attorney, round and round we go. So we're going to be discussing that tomorrow. I just don't know that my brain can handle it. These guys are obviously many IQ points above me. I'm just a blue-collar guy from Jersey listening to Bon Jovi in my spare time. Abby Crossing here. Do the judges, Judge Hyman, believe, this is speculation only, as they both don't know Judge Everett, do you believe that the judge does bear or feels he bears partial responsibility in this? And I have no idea what this acronym is, but I'm going to go, is he being held accountable by, I will say, the Florida Judicial Quality Control Center? I know that's not it. What is it?
Qualifications Commission.
Oh, close enough. Close enough.
Yeah, they supervise judges.
Close enough. Quality control.
Look, anyone can make a complaint against a judge. It's done all the time. So that doesn't necessarily mean anything. I mean, if you're not contacted, you don't know there's even been a complaint. But that's neither here nor there. Look, I can't find the judge to be in error based upon what little I know. Again, could it have been done differently? Maybe. I'm not prepared to find him at fault.
Judge, you judges, you do pretrial hearings for a reason. I want all the issues that might come up to me before the trial starts. Anything that could come up, we want to have it done outside the presence of the jury. And they had this conflict with Donna because Donna fled and he gave her advice. And he had this full hearing about, you're not going to be able to call Dan as a witness. He's not going to be a witness and a lawyer. And the judge did this multiple times where he said, Donna, you waive it. But they never mentioned the waiver with Charlie. And my knowledge is Charlie never was brought in to say he gave the waiver. And there was never a written waiver introduced into the record.
Yeah. Judge Jay, Judge Eugene, do either of you to this day have a case that still kind of eats at your craw that you feel that you could have done a better job on? Is there one that stands out, Judge Jay?
As a judge, I think about it. I think about cases that I tried as an attorney where I wish I had maybe crafted a different closing argument. As a judge, one of the conflict issues that arose for me, because my jurisdiction included not only criminal and youthful offender cases, but also termination of parental rights cases. So termination of parental rights is a child protection case. They're called dependency cases in many states. There were several occasions in which a family would hire an attorney who wanted to represent both the mother and father who were accused of abusing their child. I had extensive experience in this context in really urging clients, often the mother, not to waive what was a clear client, because you have failure to protect, who inflicted the injury, who is alleged to have caused the injury. But at the end of the day, if the judge conducts a really soul-searching and complete colloquy, it's difficult to say, no, I will not accept that waiver, although I may personally question it. So there are cases like that I've thought about over the years in the context of termination of parental rights, where I know in my heart that the litigants would have been better if they had separate attorneys, because almost per se there's a conflict or the possibility of a conflict.
And Judge Eugene, I'll come back to you in a moment, but Tim, this question's been up for a while. Would Donna and Charlie ever offer a double deal, mom and son, for them to have reduced sentences to turn on Wendy? I think that is the ex-wife of Dan Markel. I think Dan wanted to be off the case after the comment in the elevator. He had allegedly made a comment in the elevator that Donna was going to pretty much blow her top when she found out that Dan was going to remove himself. But what about this notion that they team up? Again, the theme tonight is plea deals. Any possibility, Tim, that you see of them coming together to sink Wendy for their own benefit?
Well, they do not normally make a plea deal with someone that goes to trial and commits perjury in a first-degree murder case. They do not go back and then say, "Oh, we're going to give you a deal." I do not. What happened here was his appellate lawyer is a very good appellate lawyer, one of the best in the state of Florida. He went out and saw his client, and during that conversation, apparently, he expressed to him he had a good ineffective assistance of counsel claim. And so at that point, he told and advised his client probably not to waive any privileging, do not testify in the trial of your mother. The lawyer then files a motion. That happened on a Friday. He got here. He saw him on Saturday. The motion was filed on Monday. So Charlie, in effect, took the only lifeboat there was away from the mother. And he's on his own paddling away.
Judge Eugene brought this up that a judge will consider the victim's family. If there's any silver lining in this horrible tragedy, is that we become friends with Dan's mother, Ruth, his father, Phil. Phil, I owe you a call, and his sister, Shelley. How heavily will Judge Stephen Everett, whoever the judge might be down the road, weigh the input from Dan Markel's own parents and sister?
Well, again, I'm a bit of a kibitzer here. I think we have local talent to understand Judge Everett certainly more than I do, but victim impact statements of affected parties are part of the sentencing calculus. There's suggested sentencing guidelines in most jurisdictions. The question is, in making a sentence is, you want to craft a sentence which is fair and proportional, one that balances accountability with other legitimate sentencing factors. So that's a very, very difficult question, which implicates judicial sentencing philosophies and a whole range of other issues. The bottom line is you don't want to let emotion overwhelm fairness. Of course, this is a murder case, so you're dealing with penalties that are required. It's a different situation if you're in a discretionary sentencing regime. When you have statutory requirements, where you're talking about life without parole as a requirement, or a specified term, say 25 to life with a parole eligibility date, that informs the range of sentencing options. And certainly victim inputs will be heard during sentencing.
This question, even though it says it's for the judges, from Dawn, is really a Tim Jansen question because he knows Georgia and Sarah Catherine, as the state attorney refers to her. They are the prosecutors on the case. Georgia, the lead prosecutor. Tim, it's interesting when you go back, and I don't remember exactly what Georgia said, but it was something along the lines when the judge asked her after this all happened if she wanted to make a statement to the court. She said something along the lines of it would not be appropriate at this time. It sounded like she wanted to drop a nuclear bomb on Dan Rashbaum at that point. What do you think's happening to her mindset a week out of this, and Sarah's as well?
Well, they prepare and they get witnesses transported. They spend a lot of money, a lot of time to get witnesses prepared, transport them. You got inmates being transported from all over the country, and they clear their calendars. They divvy the work up. They've got victim witness coordinators doing this. This takes a lot of work to get this on a murder case. And they're disappointed. They were ready to roll, ready to go. And witnesses who don't want to come testify, it takes out of their lives. So when they get there, they think it's going to be over. And now they come here or almost get here. And now it's got to redo it. They don't like it. The judges don't like it because this was like a 2-week, 3 weeks docket. You take a 2 or 3 week docket from a judge, who's got like 600 cases, they're not happy. And it's just problematic. It slows down not only this case, all other cases. All other cases are
Yeah.
affected.
Speaking of affecting all other cases, Judge Eugene, I think you touched on this, but wouldn't mind if you went a little bit deeper on what is now the interplay between the appellate attorney, a guy named Michael Offerman for Charlie Adelson, and Judge Stephen Everett, who presided over the case. Is there any interconnectivity ex post facto here after this all happened? Who does the appellate attorney confer with? Is it this judge or another judge? How does that all work?
Oh, he's conferring with the trial judge, but the trial judge is assessing the credibility of everyone who appears in front of him. I mean, lawyers, witnesses, everything. So it is very important that this attorney, all attorneys, have a very good relationship with the judge, that the judge has great respect for him, and that the judge is confident in terms of what is being represented to him by any of the attorneys, in terms of having an effect in terms of how the judge ultimately decides what to do. If you don't have confidence in what this lawyer is telling you, you're going to have a completely different outcome.
Yeah. Tim,
is it fair to say, Judge, that other judges talk about the credibility and truthfulness of a lawyer?
Lawyers talk about judges. Judges talk about attorneys.
I can promise you that is true, Judge.
Tim's been on the receiving end of that. By the way, there was a comment from a woman.
I've never been held in contempt.
Yeah, there's a comment from a woman.
Still time.
Still time. She says she has not seen this many judges since her divorce. So there you go. It's probably triggering some PTSD.
That's a very interesting comment. I was in family court for 2 years, and I was amazed at the number of parties that had multiple attorneys. And I looked into it, and what happened is the party retained the lawyer for anywhere from $3,000 to $5,000. Go through the retainer, the attorney would make a motion to withdraw. The party would save up some more money, go to a different attorney because they were upset with the first one. And by doing that practice over and over again, wind up with 3-4 attorneys before the case is even over.
Yeah, that's really interesting. In Massachusetts, and I think nationally, the great majority of clients in probate and family courts are indigent. So I think you're talking, Your Honor, about the rarefied clientele. 75 to 80% of litigants in family court are pro se.
Oh, that would be true in California as well.
So when an attorney is representing one party, there's an incredible power disparity and knowledge gap between how to navigate the incredibly complicated legal system, which puts the onus on the family court judge to bend over backwards to make sure that the due process rights of the pro se litigant are not compromised.
And in California, the judge is encouraged to do just that.
By the way, I don't think being a judge is that stressful, because look at Judge Jay and Judge Eugene. These guys look great, fantastic, spry, still dishing out all the information. They look relaxed. Judge Jay, I was disappointed. I asked Judge Eugene. He does not have a forever placard for his car that gets him prime spots. I know parking ain't easy in Cambridge. Can you just roll up and double park since you're a judge?
Oh no. And first of all, I'm retired.
Yeah.
So I used to have judicial parking at the parking lot. But as any judge will tell you, if you try to use your judicial office to get any favor, that is a one-way ticket to what we call the Judicial Conduct Commission.
Yeah.
And we have a very, very robust ethical code of conduct for judges in state courts in Massachusetts. Apparently, that the Supreme Court of the United States hasn't gotten the message.
Yeah. By the way, it can be dangerous. Just today, a judge in just north of New York City, he unalived himself as the FBI was closing in on him. He had taken some bribes. He's a judge.
No, he took bribes as a prosecutor. And then became a judge.
And
he didn't take the bribes.
He opened fire on the FBI.
That's how he became a judge.
Probably.
Forgive the cynicism.
Yeah, and by the way, tomorrow we're covering 11 a.m. tomorrow. Everybody, we're taking. There's a kind of a crazy story out of rural Kentucky right now. A sheriff, not a deputy, the sheriff went in and basically in cold blood executed the judge. There's rumblings about why that happened. No one knows for sure. I've gotten some sources telling me some interesting things, but we're going to take that hearing live tomorrow with the General Mark Davidson, who's a district attorney out of Tennessee, and Scott Duffy is going to come on. That's at 11 a.m. tomorrow. If you're interested. Also, if you're enjoying the back and forth with all these intelligent legal minds, please hit the like button. Please subscribe. Please share it with your friends. Tell your friends. It's the smartest show on all the YouTube. Back to Judge Eugene here. How is Judge Everett not in conflict by presiding and ruling over both trials? Can you explain that?
Oh, I don't think there's necessarily a conflict because he's not the trier of fact. And I think that's the most important factor is he's not the trier of fact.
Right. So this would be if you're a judge and you're listening to a criminal case and you've heard a dispositive evidentiary motion to suppress, you've denied the motion. If the attorney doesn't go to a jury trial, then he or she should hand in their bar ticket. That would be an example of bias, and most jurisdictions allow for a request for recusal.
Oh, absolutely.
Yeah,
absolutely.
California included.
Tim Jansen, do you, on a serious note, do you get nervous in front of judges, Tim? You're pretty unflappable, Tim Jansen.
No, he doesn't get nervous. I guarantee you he doesn't get nervous.
No, Tim? No?
I can tell in the hour that we've spent together, he's a pro.
Hold on, you haven't heard stories about Judge Hankinson yet. Hammer and Hank.
I don't care what the story is. He's a pro. He can handle it.
No, because one thing you do, you never lie to a judge.
Exactly.
No client is worth it. You never put the judge in a position.
Exactly.
They trust you and it's misguided.
Exactly.
They'll never trust you again.
Exactly.
I had a federal judge when he first got on the bench.
They're different.
And he made a mistake. And I told the judge, you made a mistake. You forgot these points that you were going to give, but you didn't add them up. And I just want to let you know that. And he said that he will never forget that his sentence didn't get overturned because I corrected it, even though it was to the dismay of, I have candor to the court. I couldn't sit there and do that.
It's a rare defense attorney that would do that.
Yeah, Abby Crossing, very smart. She made the analogy about why he could preside over 2 trials. She said the analogy is referees can call all games in the league. Good way to look at it. That's why Abby Crossing.
That's exactly the same thing.
Yeah. Abby Crossing.
Although Michael Oliver should be disqualified from reffing any future Arsenal games, but that's a whole other issue.
Yeah, that's a whole other issue. I'm not a big football watcher, but
second red card was weak against Man City.
Yeah, so let's listen to this. So Judge Jay and Judge Eugene, on a kind of serious note here, Amy in New Jersey, the greatest state ever created, have either of the judges ever felt scared of potential violence against them? It can be, family court, Judge Eugene.
Oh, all the time in family court. Absolutely.
Yeah. Is it true that family court is much more frightening than criminal court?
Absolutely.
Mm-hmm.
Well, the highest rate of judicial conduct complaints
absolutely.
in most states annually involves aggrieved parents in divorce cases.
Absolutely.
Or custody cases.
Yep.
Fortunately, I didn't hear those cases because juvenile court in Massachusetts does not involve those cases. Those cases go to our probate and family court. But I did hear many contentious termination of parental rights cases. The stakes are high. These cases are like the functional equivalent of the civil death penalty. Think of how you would feel if you lost custody of your child. You'd rather go to jail, right, than lose custody of your child. And that's where a lot of emotion is to be expected. And a lot of complaints are made. And unfortunately, some of the incidents of violence against judges occurs in that context.
Absolutely.
Yeah. So you guys talking about lawyers. Rosemary Romero outside Toronto wants to know, do other judges judge other judges? And is there any kind of oath that says that judges should not criticize other judges? So what's the scoop, Judge Jay? Do you go back in your chambers and talk mad whatever about another judge?
So first of all, a credo that I had on my bench was that a judge should not be judgmental. That includes not only an admonition for myself to listen reflectively, but it's also dangerous to opine about the conduct of other judges. Now, I was a first justice, so I had administrative responsibilities. That doesn't mean that I could tell another judge what to do in his or her courtroom, because within the confines of that courtroom, they made the decisions. That said, if you have direct knowledge that a judge is violating the canon of ethics, in some circumstances, there is an affirmative responsibility to report that conduct. I'll let you know, in the 24 years I was a judge, I never went down that road, nor did I ever file a complaint against an attorney for trying a case with what we call our Board of Bar Overseers. But there is that provision.
This Jimmy McNutty, everyone makes fun of me, but I always preface it by the fact that he's been a trial watcher. He was at the O.J. Simpson trial and has continued to watch trials ever since. He's a retired aerospace engineer. I think I'm allowed to say that. I met him in L.A. at my book signing for the judges. We just played this, by the way, Judge Jay, before you came on. I did an interview with Dan Rashbaum where he basically said he had everything in order. This was back in January in terms of the waivers. So the question is, Judge Eugene, I'll go to you since you just watched it. If Dan Rashbaum, lied in the STS interview about the Adelsons having an independent counsel for the waiver decision, can the bar use that to sanction Rashbaum? Some people have filed, at least one person that I know of has filed a bar complaint against him. Your response?
Just because a bar complaint has been filed doesn't mean there's a bar investigation. I mean, when I was in family court, I received a lot of complaints to the state bar. How do I know this? The parties in front of me were always telling me that I had to recuse myself because they made complaints about me to the state bar. To judicial performance. They say, you can't possibly hear my case. I've made a complaint to the judicial performance about your conduct of my case. And I say, well, I can tell you that I have not received any communication from the Commission on Judicial Performance, so I know nothing officially of your complaint. Number two, however, because you tell me that you have filed a complaint, now I need to take a step back and reflect. Now that I know that you have said that you have filed a complaint against me, now can I be fair, neutral, and impartial? And the answer is yes. I have reflected. I have decided that I can be fair, neutral, and impartial, even though you have made a complaint. I understand that you're unhappy with how this case is going. I understand that. I understand that you're unhappy with some of my rulings. Then he interrupts me and says, with all of your rulings. Okay, fine. So you're unhappy with all of my rulings. I understand that. But just think how easy this would be if all a party had to do to get a new judge was file a complaint with the regulatory agency and they'd get a new judge. I mean, every judge would be facing complaints all the time. Now, if you get a complaint and if it's investigated and if there's substance to it, different story. But in my 2 years in family, I don't know how many complaints I received because I can only say I never was required to answer a complaint that was filed. I have no idea how many complaints were filed, but given, as Judge Jay has indicated, the high number of people that are self-represented, I'm assuming I've received a lot of complaints, but I never had one where I had to respond to or one that was investigated. But you can't, a party can't use the filing of a complaint. And in California, what they would do is two-step you. They would file a complaint with the presiding judge, equivalent to the chief judge of the court, and then they'd also file a complaint with the Judicial Performance Commission. Now, the presiding judge was required to pass the complaint on to you, and you had to respond to that complaint. And then the presiding judge would decide, based upon your information and the party's information, whether she had a responsibility, sua sponte, on their own to file a complaint before judicial performance. So I was aware a couple of those because it was sent to me to respond. And then, of course, the party would say, I mean, they must all get together and talk about strategy for how to get rid of judges. So then they would say, well, I filed a complaint with your boss, and then I filed the same complaint with judicial performance, and I want you to recuse myself. Well, I filed a response to my boss. She has not removed me, and I have not heard from judicial performance. I have stepped back. I have reflected. I've decided that I can be fair, neutral, and impartial. And then the party would say, well, certainly you would like to get rid of me. So that's not the standard. The standard is whether or not I can be fair, neutral, and impartial. I have a responsibility to do your case as long as I don't have a conflict and as long as I can be fair, neutral, and impartial. As of today, I feel I can be fair, neutral, and impartial. Then the response frequently was, I'm going to make a complaint every time I'm in front of you, and at some point, you're bound to recuse yourself. I said, well, if you continue to make complaints, I'll continue to reflect, and I'll continue to decide on a case-by-case, day-by-day basis whether or not I think I can be fair, neutral, and impartial.
So the recusal rule in Massachusetts is similar, but I think it's a two-step recusal process. One, subjectively, do you think in your heart you could be fair? And then two, is there an appearance of impropriety if you do not, to a third party recuse, to the public? So that second prong is more complicated. But I want to get back to what your question was regarding Attorney Rashbaum. So as regards the attorney, a citizen, a litigant, or the bar council, whatever it's called in the given state, on their own can initiate disciplinary proceedings, first with an investigation for alleged misconduct that can result in censure. Usually the process starts anonymously. So this also tracks what goes on with judges. We don't know right away until we get notice, maybe a letter, a certified letter. That's when you got to contact an attorney. So, no matter what, notwithstanding what happened in court with the waiver and the withdrawal, the bar disciplinary board can on their own or via a complaint investigate a case and then take what they deem to be appropriate action, assuming that there's a modicum of due process for attorneys. One of the problems with disciplinary proceedings regards attorneys is that the system is rather opaque, and many people who make their livings representing lawyers in bar disciplinary hearings say that lawyers get less due process and fairness than their clients do in court. Burdens of proof are preponderance of the evidence, not proof beyond a reasonable doubt. Some have argued it should be clear and convincing, because you're talking about potentially losing your ticket, your license, your ability to earn a livelihood by practicing law.
Yeah, that's a great point. Tim, this is a big what if, and I think the answer, I know the answer. Could Georgia go above Jack Campbell's head to the state AG if she felt the case was being mishandled? She probably can, but she would never do it, right, Tim?
Well, why would what is being mishandled?
Yeah.
Two, he's the elected state attorney. She's an assistant. She works for him. And so if she went above his head, I think she would probably not be a prosecutor in that office anymore. But I don't know of anything that's being mishandled.
Yeah.
I mean,
by the way, this is Jack Campbell holding a press conference the day after. It's a very rare occasion. I think Tim can tell you that. Here he is speaking about what transpired and the whole plea deal possibility.
Morris is a great trial attorney. I think he'd, if he says that, I look forward to it. Once again, there's a reason why plea negotiations are supposed to be kept confidential, and so I'm not going to speak as to it at all. I can tell you, we probably 99% of the cases this office handles are resolved through some type of negotiation. So we're willing to negotiate and talk. Have no fear. nothing will be done without consultation with the Markel family. So there's nothing secret that will be done. We don't talk about it because, candidly, for negotiations to go back and forth, the law requires it to be confidential on both sides. So if he wants to begin negotiations, I would love to do negotiations. We negotiate on the overwhelming majority of our cases. I look forward to talking to him about it. Once again, Ms. Kappelman would be the point on that, but I'm sure I will be consulted. But there's nothing secret that's going to happen where this would be. And I think the fear of a lot of people watching this interview or reading your paper, if there was a negotiation, it would all come out before it was finalized. So we would know.
This is very long. I'm going to stop it right there. Tim Jansen, I mean, we got your reaction. He doesn't do this often where he holds these press conferences. What's he saying to you when you're reading between the lines here?
Well, he had to save face and at least address the public because this trial was continued it's a national trial. The victims want their justice. So he had to come out and say, we are here. My people are ready. We're ready to proceed. If he wants to come talk about a plea, we'll discuss it, but we're going to consult with the victim's family. There was really nothing here that was said that's of substance. And he really can't talk about the case. It's pending on the docket. He can't talk about the facts. So he really didn't say anything except he had a press conference.
Yeah, I'm going to play a couple more, maybe another minute, and I'll get the reaction from Judge Eugene and Judge Jay.
Notify the media, the family would know, and there's no secret deal. Everything will eventually come out, but it begins in earnest through conversations back and forth. And so that would be just like we don't tell y'all while we're investigating a crime what our evidence is. We eventually show you our evidence in trial. That would be same with a plea negotiation, just like anytime y'all come and see us pleading a case out. The terms of the plea are all discussed. The family is consulted, and we'd be able to talk about it. But it's way too early at this point to anticipate if the negotiations will go anywhere and what any terms would be.
I'm going to stop it there. Judge Jay, you got the hand up already. Go ahead.
Yeah, so this is problematic. We're talking about a trial which was involved a case which was almost impaneled. Talk about maybe adversely affecting the venire. You start putting it out into the ether. We're talking plea. I'd be really concerned, about that because of the implications. So I think, sure, plea negotiations are not supposed to be spoken about for a lot of reasons. One of the reasons is pre-trial. You might be compromising a defendant's presumption of innocence by encouraging people to think that a deal is in the works. What are you going to plead to? A lesser included? You're going to try to argue that there's no joint venture to make her a principal. She's an accessory after the fact. It just leads to incredible speculation. I think that's kind of, less said about that publicly, the better, unless there's some really meat on that bone. It concerns me as given my belief about the presumption of innocence. So that's concerning to me.
By the way, there's a rule on the show. I cannot bring up my book, but Nan R, of course, just did. It's a running joke, I guess. I have a book out about my beloved mother, my co-host, who's right over here and here, both sides. She is a Holocaust survivor, hence the name of the show, Surviving the Survivor, which I try to do every day. Karma's getting out of Dodge for this hurricane. She's going up to Jersey to see my beloved sister. But the book is 10% how she was hidden by a Catholic nun, saved by two non-Jews, what they call righteous Gentiles, in a Catholic school for boys. And then 90% of the book after that is my mother screaming and yelling at me and giving life advice about everything from children to having judges on my show, to technology. The list goes on. Surviving the Survivor is the book. Anywhere books are sold. That includes Barnes & Noble, Amazon, the Walmart, all those places. And I just found out I'm getting invited to the Tucson Book Festival in March. So if y'all are in the Tucson area, I will be there then for that. People loving both judges. Tim Jansen, one of the questions was, why wouldn't Alex just remove himself. It seems like, like this is going to be an unmitigated disaster if he stays on. Tallahassee is not, a huge community, and why would he want to deal with the aggravation? Is it a money issue, or is it a just a integrity issue that he wants to stay on to show that he can handle this?
I can't speak for Alex. I think Alex has gotten thrown into the fray, right? Trial didn't even start yet, and he's trying to defend this thing. It is going to be a headache. They've never hired a Tallahassee lawyer. I expect them to hire a Miami lawyer that's consistent with the pattern that they have. I don't know if the money's going to be good or if Alex wants to take on this. I don't expect this case going to trial for a year, because any new lawyer is going to have to get in there. And if he's going to come as part of Alex's team, he's going to have to ethically build another wall. So he's got to learn all this on his own so the judge will be ensured that there's not taint from the co-lawyer who was on the team when the conflict arose. So the easiest thing is Alex withdraws. She hires 2 new lawyers or a lawyer. They start fresh and there's no conflict. That's the easiest way to get a clean trial.
And Tim, what does that mean for a trial date? Let's assume that happens. Alex bows out. Now, a woman that's entitled to a speedy trial, defendant, doesn't matter that she's a woman. How long before there would be a trial?
Well, she can ask for a speedy trial and the court will have to do it. I expect she's not going to ask for a speedy trial, and I expect it'll be a year. In our circuit, murder cases don't go to trial before about a year, and that's a fast pace in our circuit.
Yeah, she'd be 75 years old, still plenty of life ahead of her. By the way, someone says, come to the Detroit JCC. I think I'm about to be invited to the Detroit Jewish Book Fair, the largest Jewish book fair. Who knew, in the country? From Shell here, can a membership level be an OJ trial level, an OJ trial watcher level membership? The COE will get on that. We will have an OJ trial watcher level that you can join as. Judge Jay Blitzman, he was watching trials before OJ, and he'll be watching them after OJ. And he is a gentleman and a literal scholar. He was the first justice of the Massachusetts Middlesex County Juvenile Court Division. He was a criminal defense attorney before that. He teaches at Harvard Law School. Judge Jay, what is something people don't know about judges, and your final thoughts?
Well, I think what people may not know is we're just like everybody else. Hopefully we maintain the same sense of humility and humor that we had before we were judges. God help me from the judge who takes himself or herself too seriously.
As Oscar Wilde once said, and I tell my kids this, they have no idea what I'm talking about because they're too young, but life is too serious to be taken seriously. An Oscar Wilde quote. I love that.
I second that emotion.
Yeah, thank you. Eugene Michael Hyman, the Honorable Eugene Michael Hyman. He is an American retired judge. That's in your Wikipedia. That's why I keep saying you're American. I don't mean to. I think we all know that. Retired judge, lawyer, and this struck me, former police officer, of course, from Perth Amboy, New Jersey. What a small world.
Whoa.
Yeah, we played them in high school tennis. No offense, but we used to crush you in high school tennis. So
Well, I didn't go to high school there. I went to high school in Mattawan.
Oh, Mattawan High. There you go. All right.
Go Huskies.
What's that?
Go Huskies.
Yeah, go Huskies. By the way, Judge, I'll make this public right now. My best friend owns a jewelry store in Manalapan, New Jersey. If either of the judges need jewelry, you come to me. He gives me a 1.5% discount. I will get you 1.5% on anything you want. I've been haggling. Let me tell you something. This guy, his dad wanted him to understand business, so he bought him a Carvel ice cream franchise after college to learn how to conduct business. And I used to occasionally fill up the chocolate vanilla swirl in the cone a little too high, and I would get yelled at by him. I had to be a little more skimpy with my my doling out of ice cream cones. So
Love the chocolate vanilla swirl.
what's that?
Love the chocolate vanilla swirl. Miss that.
He doesn't have the Carvel anymore. But Judge Eugene, before we get your final thoughts, I'm fascinated. How did you go from police officer? Where were you a police officer to lawyer and then ultimately judge? That's quite the move.
Well, I was a reserve police officer. I was an undergraduate at Claremont Men's College, now Claremont McKenna College. I took a criminology course, and the course required that you go on either a ride along with the police, you spend time in the state. We had a couple state prisons in the area of Claremont, or some other type of criminal justice activity. So I went on a ride along. I spent some time at the local prison. And I did something else that I can't remember. And then I became a reserve police officer because you had to be 21 my senior year at Claremont. And then I wasn't admitted to my first choice law school. So I had to decide what was I going to do. I decided to be a police officer.
What was first choice law school? I got to ask.
No, I'm not going to say. So
it was hard.
No, it wasn't Harvard, or Yale, or Stanford, or Berkeley, or UCLA. At any event, you got to be realistic. So, at any event, so I applied to police departments in cities in California that were near law schools that had part-time divisions, and I was accepted at the Santa Clara Police Department. Then I applied to the university. It was then the University of Santa Clara. Now it's Santa Clara University Law School. And ultimately I went there. And unfortunately, my last year of law school, I was involved in a bad car accident and I got disability retired. So then I had to decide what to do. And I did what I swore I would never do. I did criminal defense for a couple of years. And
There you go.
I swore I would never do it because of my police experience, but it's the best thing I ever did because it taught me a lot about humanity, and it taught me that most people are good who occasionally make mistakes. I mean, there's very, very few evil people in the world, and so then after practicing for 12 years, I applied to the bench. I was a Democrat appointed by a very conservative Republican governor. Governor George Deukmejian was the municipal court judge for 6 years. A vacancy occurred on the Superior Court where a judge let his office go to election. In other words, he didn't run again and didn't retire during the term, allowing a governor to appoint. So I ran for an open 6 years, received the vote, and was elected a Superior Court judge, and I served there until I completed my 20 years. I was in every assignment but dependency, although you see dependency cases in family, you see dependency cases in juvenile delinquency or juvenile justice, and of course 50% of juvenile justice cases go on to the adult system. 50% of the dependency cases go into the delinquency or juvenile justice, and a certain percentage of dependency cases are in the family law as well. So it's all very, very complicated. But at any event, the hardest assignment I had in 20 years was clearly family, because as Judge Jay indicated, 75% don't have lawyers. And the most difficult decisions you're making are with respect to child custody, visitation, and access, and you have insufficient information to really make a good decision. And those are the ones that I lost sleep over, and those are the ones that I occasionally think about are the child custody decisions.
By the way, Space Coast, I think he went to Santa Clara. That's my brother-in-law. That's the COE's brother. COE, let me know if that's true. I don't know why I'm kind of blanking on that, but I feel like he did graduate from Santa Clara, and I was there, I believe, at the graduation. Although the last 12 plus years have been a bit of a blur. Look at this from Cindy. One of the best shows I've watched in a long time. They're all great. But this one, as Judge Eugene was speaking, is exceptional. They're all exceptional. Thank you for a great show. Of course, the man who is my right-hand man, who knows everything about Tallahassee and criminal defense, who swore he would only do criminal defense so he could get that nice house of his in Tallahassee, and it is a nice house. Famed Tallahassee defense attorney R, the letter R and O-U-R, Timothy Jansen. He works for the firm that bears his name, Jansen and Davis, which is a beautiful law firm. Spent 5 years as a federal prosecutor. Tim Jansen, you know this case better than anyone. What happens here? It's 14 years. I'm sorry. Marriage is 12 years, 14 years together, I guess. So I digress. But Tim Jansen, does Alex stay on? Does he leave? What are the next steps with this case? When does Donna go to trial? Please answer in under 3.5 seconds. No, you can take as much time as you want.
First of all, I want to say this was a brilliant show because, we have all these viewers come in and they talk about lawyers, they talk about judges. And if the viewers don't like what happens or a ruling happens, they criticize the judge, and they don't realize judges, they're lawyers also. They're trying to do the best they can. They get assigned a case. They don't take personal interest in the case. They're the referee, right? They're to make sure it's fair on both sides. And you'll see these two judges, very learned, very bright, and they tell you how it really works, what really happens in the courtroom. And I love the fact, I love every judge who's ever done criminal defense, because it gives them a viewpoint of what the defense lawyer is going through that you wouldn't see if you just became a prosecutor and went to the bench. This trial is going to take a long time. I think Alex is going to take time to reflect. Is it worth the money for the hassle of this case? Is it worth the money on a case that looks like it's going to be a loser? Do you want to go on public TV and lose a case? Now, there are some people that want to do it 2 reasons. 1, for the limelight, and 2, for the money. But sometimes when you get older as a lawyer, you realize that's not the most important thing anymore. Your family, your sense of not carrying this burden, because when you represent a defendant, you represent the family, not just the defendant. And I'll end it with this, because these judges will appreciate that. I was in federal court making an argument, and the judge looked at me and said, "Mr. Jansen, we both have roles. My role is to listen, your role is to talk. I just want you to know I'm done, but you keep talking." And I basically realized, shut up. It's over. And I'll never forget that when he said that. And I appreciated it, because I learned from that. You can talk too much.
Tim Jansen, would you rather be a co-host on STS, or, as Miss Little Bones says here, Tim, will we ever see you as a judge? Are you going to either run to be a judge or be appointed? Do you have aspirations to make that the next step of your career, Tim Jansen?
Someone asked my wife if I would run for judge, and she said no. And they said, why? And she goes, because he might win. And she doesn't want to be a judge. Is a difficult thing. And my good friends are judge. My little brother's a judge. We have a great relationship, but when they become a judge, they have to limit who they can go out, where they can go. Like, they won't come to my Christmas party, because just in case we appear before each other. So they sacrifice a lot to being a judge, because they have to be impartial and have to appear impartial. But you know what? They're great people. They're funny. I always get a kick, because when I see them outside of the bench, do I call them judge or whatever? And they've all said, "Tim, we're off the bench. Just call me by the first name," which is nice. And they appreciate that too.
Yeah. Look at this, Judge Jansen. Hashtag Judge Jansen. Terrific show this evening. Huge thanks to the 2 judges, Judge Jay, Judge Eugene, and of course, criminal defense attorney Tim Jansen. Tomorrow, we will get back on this 7 o'clock. Again, talking about attorney-client privilege, what happens with all of that. We reached out to Louis Baptiste. Steve Cohen is working on that. But at 11 a.m., why did this Kentucky sheriff basically execute a judge in rural Kentucky? That sheriff is in court tomorrow. We will take it live with the General Mark Davidson and retired FBI agent Scott Duffy. Until then, love you, America. Love you, Watertown, Cambridge, Harvard, Northern California, Santa Clara, Tallahassee, and of course, it's all about justice for Dan Markel. Guys, stick around for 1 minute, and we'll be back tomorrow, everybody.